Hello everyone, welcome to Satva Academy. As we announced in our last video, we are starting the rapid revision batch for the CS executive exams. Before starting the video, I would like to wish all the best for the students who are giving the December 2025 attempt of company secretary exam. So here I will be starting with the company secretary's first module, second paper, that is company law. So company law is an important paper for the company secretary course. So here I will be starting with the first unit of company law, that is introduction to company law. Okay students, let's start with the first unit of company law, that is introduction to company law. See here in this chapter you can expect around 10 to 12 marks in your exams. So there are some important topic which is repeated in last exams. See under that, ultra virus transaction, doctrine of alter ego, doctrine of constructive notice, exceptions to doctrine of indoor management, and also lifting the corporate veil. So these are all some important areas where you can expect the question for your upcoming exams. Okay, let's begin with the ultra virus transaction. Hope you have read and understood the question. Let's start with the analysis of the question. Okay, before analyzing the question, let's understand what is ultra virus. See, ultra virus means beyond the power. So what is the power related to company? See, for example, so this is a special form of business where it is different from the any other form of business. For example, you know there are many types of business form, that is sole proprietorship, partnership form, LLP, and company form of business. So here in case of company form of business, there is a lot of opportunity when it compared with the any other forms of business. But the thing is, when you want to start your business under company form, then there are some restrictions that should be followed by the investors or as the businessman. Okay, see, assume when you want to start your business under company form, then you have to register your business under ROC, that is Register of Companies. So this is a compulsory condition for the company form of business. Before starting your business, you have to register your company under ROC. Okay, while registering the company under ROC, there are some compliance to be followed by the investors. That is, you have to make some important documents for the company's incorporation. That is nothing but MOA and AOA. So these are the two important documents which gives the power and authority to the company, and also for the company's employees, because company is a special form of business where the management of the company is managed by the internal employees and not by the shareholders of the company, because here in case of company it enjoys separate legal entity. So that is the concept, so that when the other persons or else the management is different from the investors, then there should be some prescribed procedure to rule the company. For that purpose, here under MOA you are giving the powers to that company, means which kind of business that company can carry in future. So for that, in a MOA there is an object clause. In an object clause you are going to mention the objective of the company. Okay, based on that you have to carry your business activities under your company. Suppose assume if a company violates the provisions given in the objective clause of the company, then it would be treated as a ultra virus transactions, which means which is beyond the power of the company. Here you can understand the company's authority by reading the provisions of the objective clause of the company. For example, assume you want to start a software company. So in that case, you can form a software company by mentioning the software related business under your business MOA's objective clause. So once you mentioned your business in an objective clause, after that, after forming the company, you can't change the business objective. So that is a condition for the company form of business. Okay students, hope you have read and understood the scenario of the question. Let's start with the first concept, that is ultra virus transaction. Let's see how it affects the business of the company. See, in a given question, there is a company, that is Innovate Tech Limited. See, as per MOA of the Innovate Tech Limited, the main objective of the company is to manufacture and sell the computer software. That is the power of the company, so that the board of directors of the company can make any transaction which is related to manufacture and sale of computer software. That will be the power of the company. Okay, then later board of directors saw the profitable opportunity in the purchase of plot of land for the real estate development. That is the concept in the question. So now there will be an objection by the shareholders. Now you have to decide as per the question whether the objection made by the shareholder is right or wrong. So while reading the question itself, you have to compare it with the legal provisions applicable for the question, so that you can save some times in your exams. Okay, let's see. Your answer should contain three parts. first you have to analyze the situation given in the question, and second part is applicable legal provisions to that scenario, and third part is the conclusion, that is the answer of the question. Here you have to make a suggestion as required by the question. Okay, let's analyze this question. See, as per the question here, Innovate Tech Company Limited incorporated to manufacture and sell the softwares. Here the act of purchasing the land for the real estate development will be the Ultra Virus Act, means entirely outside the scope of the stated object. So in a given question you can know that the company's authority is related to only manufacture and sale of computer software, not these kind of transactions. Now the sector is different. Here these transaction belongs to real estate sector or its infrastructure development companies transactions. Okay, here the thing is, here director found the profitable opportunity to make a profit for the company's purpose. Director made a transaction here. Now you have to see whether this transaction is valid or not. For that you have to go through the legal provision given in the company's law. Okay, so what is the legal provision here? As per the section 4 subsection 1 and subsection C of the Companies Act requires the MOA to state the objects of the company. See here, as per the company law, so here MOA to state the objects of the company while incorporating the company. Okay, now the doctrine of ultra virus concept. What is the doctrine of ultra virus? See, doctrine of ultra virus means any act done or else contract made by the company which travels beyond the power mentioned in its objective clause, that will be null and void. So you know, as per the contract as null and void means those transactions don't have any enforceability by the court of law. So the problem is here, if any company makes any transaction which is beyond its MOA's object clause, then there will be no relevant legal remedy for that act. Then company may have to face the loss. So according to this question, there is a transaction which is beyond the powers of the company or else beyond the authority of the company, so that the objection made by the shareholders is valid here. See, the transaction is considered as void ab initio, that means void from the beginning itself. Whenever company goes beyond the objective clause, so such transaction will be treated as beyond the power, then such act will be treated as void ab initio, that means void from the beginning itself. So that for such a transaction the contract itself is invalid, so that you can't get the remedy in court of law, so that you have to avoid any such transaction in your company form of business. Now you know the legal provision applicable for the question. Now let's see what is the conclusion to be given for that question. See, here there is a conclusion part where you have to write all these points in your answers. See, while giving the conclusion you have to tell, that is, build strong construction. See, the contract with the build strong construction is ultra virus, so that the act is null and void. So anyhow, according to the Contract Act, you know that the act which is null and void, so the act will be invalid, so that there is no enforceability by law. So that here the shareholders objection is valid. You can give that suggestion. Here the objection made by the shareholders is valid according to the company's law, because the transaction violates the authority of the company or else which is beyond the power of the company. And here contract cannot be enforced by the build strong construction and the company cannot proceed with it. Company can discharge the contract by considering the ultra virus nature of the transaction. Now the shareholders can seek an injunction from the court. Even court will also give an injunction order to invalidate the contract, because it violates the provision of company law. That means it violates the ultra virus provision. So according to the company's business, you have to go through the MOA before making any transaction. First you have to see whether that transaction comes under the authority of the company. Then only board of directors can make a transaction, even though there is a profitability for the company. Because the problem is, if in case a company met with the loss because of such a ultra virus transaction, after that company cannot file a case in court of law to claim the compensation. To keeping that in your mind, you have to give this kind of suggestions in your answer. So that will be the right thing in your answer. you can suggest here that shareholders objection is valid according to the company laws provisions. So this will be the answer pattern. Here your answer should contain analysis part and legal provisions and also the conclusion for the asked question in the question paper. See the question. Mr. Aryan is the sole director and holds 90% of the shares in a Aryan Ventures Private Limited, and he uses company's bank account to pay his personal international holidays, children's school fees and home renovation. So this is the first point. Then the company defaults on a loan taken from the secure bank. The bank sues Mr. Aryan personally for the recovery of the loan, arguing that the company was merely a other self. Will the bank succeed? So let's see. What is the nature of company? So as per the characteristics of the company, company is a separate legal entity. Whenever a company makes any default, then company itself is liable and not the specific shareholder or else the director, even though they holds 90% or else 100% of the shares also. Then how come a bank can claim against the Aryan here? Now you have to see. There is an advantage of separate legal entity in case of company form of business. That not means you can misuse the status of the company, because company after incorporation it will get a juristic personality. Juristic personality means it is an artificial personality where it gets the contractual capacity to make a contract. Okay, let's see the applicable legal provisions. Okay, let's analyze the question first. So this is the first part in your answer. First thing, Mr. Aryan has extensively intermingled his personal finance with the company's funds. That is the first mistake made by the director of the company. Being a company's director, he don't have any right to make use the funds of company for his personal purpose. See, by using the company's account for personal expenses, the kind of expenses made by the Aryan is all the personal transaction and not related to company's business transactions. Okay. Now, he has treated Aryan Venture Private Limited not as a separate legal entity but as his personal wallet. See, for all his personal transaction, he used company's fund to pay the bills. Now, after that, he took a loan from the bank for the business transaction. After that, he defaulted the payment to the bank. Now, bank is claiming that the act of the director is just a alter ego. Here alter ego means other I or else duplicate personality of the company or else duplicate personality. That is the concept. See, according to the facts given in the question, here you can clearly see that actions indicate that the company is a mere instrument for his personal transactions, fitting the description of an alter ego. So when you can consider a person as an alter ego or else a company as an alter ego? When someone misuses the company status for his personal benefit, or else whenever a person cannot do some acts, in that case he uses company's status to do that act. In all these cases you can find the alter ego. So then if any damage causes to third party, then third party can file a case against that person who misused the status of the company to claim the compensation. So let's see what is the legal provision applicable to this question. Now, doctrine of alter ego is an exception to the principle of separate legal entity. As I said, in case of separate legal entity, whenever a company meets with the laws or else company makes any default, in that cases company itself is liable and not the shareholders or else the directors of the company is liable. But the thing is here, doctrine of alter ego is an exception to the rule of separate legal entity. That means whenever a person commits any wrong by using the status of the company, in that case you have to find the person behind the company's personality to punish that person, because being an artificial personality, company cannot receive any punishment. It can pay only the penalty but not it can receive the punishment. So to prevent any such crime, here court can lift the corporate tail and make the natural person liable for those who are taking the benefits of the company's personality. Okay. Now it states that when the company is merely a facade sham or an alter ego, or its other self of its controlling shareholders or director. The court can disregard the corporate personality and hold individual personally liable. See, whenever a person misuses the company status, in that case, court can lift the corporate veil and make natural person liable to pay the company's liability. That is the concept of doctrine of alter ego. Okay, so as per this question, so what is the problem here? Being a 90% shareholders and being the sole director of that company, Aryan misused the status of the company, or else he used company's funds to pay his personal fund expenses by using the company's fund. Now the problem is company failed to repay the loan given by the bank. Now bank is claiming that company is just an alter ego of the Aryan, so that Aryan should pay the liability of the company. Okay, let's see what will be the conclusion. Okay, see the conclusion of the question. Here the court is highly likely to lift the corporate veil because of the wrong committed by the Aryan, because he misused the company's fund to pay his personal liabilities. Here secure bank will likely to succeed in holding Mr. Aryan personally liable, and he should have to pay the company's liability. Okay. So as per the facts of the question, you can clearly see that the separate legal personality of the company was used as a device. Here director misused the status of the company just to make his personal transactions. So that is the problem in this question, so that you can clearly give the conclusion that court will lift the corporate veil here and court will punish the director who committed the wrong. So now the director or his shareholder is personally liable to pay the liability of the company. Okay, let's move to the next question. First you read the question. Okay, now this question is related to doctrine of constructive notice. So what is doctrine of constructive notice? So the company is a artificial personality, and there is a rule whenever you are making any contract with the company or else any artificial personality. The rule is that you have to read and understand the documents of that company before making any major transaction with that company, and even court will assume that you have read and understood the company's document before making the transactions, because MO and AO is a public document. So once it is registered in ROC, anyone from the public can apply for the copy of that MO and AOA. So on that grounds, court will decide that you have already read and understood the documents before entering into a contract with the company. Okay. After this, if you met with the loss because of the transaction made by you and the company, then you are not able to get the remedy in a court of law. Okay. Let's see the facts in this question. See. The articles of association or else AOA of Alpha Logistic Limited explicitly state that any borrowings by the company exceeding 50 lakh requires prior approval of the shareholders via special resolution. That means if a company's director wants to take a loan which exceeds the 50 lakh rupees, then that director should get the approval from the shareholders by passing the special resolution. Here special resolution means here there should be a more than 2/3 majority or else 75% of the vote share by the shareholders. So that is the condition. Now as per question, the director without any such resolution borrowed 75 lakh from the Swift Finance. See, it is a clear violation by the director without getting the special resolution from the shareholders. They already borrowed the money from Swift Finance, that is 75 lakh rupees. So it clearly exceeds the condition of the company's AOA. Okay, then now Swift Finance did not inspect the company's AOA before lending the money. Now the question is, can Alpha Logistic Limited avoid the liability for this loan? Now the thing is, there is a condition in AOA. Whenever the director wants to take any loan from the financial institutions, they have to get the special resolution if in case the amount of the loan is more than 50 lakh rupees. Okay, let's analyze the question. See, Swift Finance, being an outsider, presumed to have read the AOA of the Alpha Logistics Limited before entering into loan transaction. So as I said earlier, AOA and MOA is a public document. Anyone wants to make a transaction with the company, they can get the copy from the ROC and they can read and understand the documents. Here also court will assume that here Swift Finance already took the copy of the AOA and they have read and understood the provisions of the AOA. Now AOA clearly places restrictions on the directors borrowing and requiring special resolution for loans over 50 lakhs. Clear? Now by lending 75 lakhs without ensuring compliances with the condition, Swift Finance acted negligently. They cannot claim they cannot claim they were unaware of this provision. So now even though they didn't go through the AOS provision, still they cannot claim that point in a court of law as a ground, because it is the condition made by the law, that is as per the doctrine of constructive notice. Before making any contract with the company, it is your duty to go through the documents of the company. Now court will assume the same. Okay, let's see the legal provisions. Okay, let's see the legal provisions. So here it is the duty of the Swift Finance to go through the AOA or else provisions of the AOA. So that is violated by the Swift Limited. Now ignorance of the contents of the MO and AOA cannot be used as an excuse by the outsiders to bind the company. Now this is the provision. So once you neglect the legal provisions of the AOA and after that you have entered into contract with the company, after that you will not get any remedy by the court of law. So here the problem is made by the Swift Finance. They have neglected the AOA and they allotted the money to Alpha company. Now okay, let's see the conclusion for this question. The conclusion is here Alpha Logistics Limited can avoid the liability for the loan because of the voidable nature of the transaction. So thing is, the transaction is voidable at the option of the company because the director acted beyond the authority as defined in the AOA, and it is the wrong by the Swift Finance. Without referring the AOA, they have give the loan, so that now company need not to enforce this loan agreement, and even Swift Finance cannot enforce against the company also because of the voidable nature of the contract. So that is the conclusion for the question. Okay, next question is related to the doctrine of indoor management. So what is doctrine of indoor management? We already discussed doctrine of constructive notice. As per the doctrine of constructive notice, before making any transaction with the company, you have to read and understand the company's documents. See, whenever you want to make any transaction, that is the compulsory duty according to the constructive rules. See, that not means for every transaction you have to read and understand the MOA or else AOA of the company. For example, a transactions like buying the products of the company. Whenever you want to buy the products of the company, in that case you need not to read the MOA of that company. That will be the waste of time. So that doctrine of constructive notice is restricted to only those transactions which is major commercial transaction and not for the regular simple transaction. And here there is an exception, that is doctrine of indoor management. So according to the doctrine of indoor management, an outsider need not to inquire into the internal aspects of the company's transactions. So here there is an option for the outsiders there that they can assume that everything is perfect inside the company's management. So that is the exception available for the outsiders. An outsider not required to inquire into the regularity in the internal proceedings of the company. So that is the exception available for the outsiders in case of doctrine of indoor management. Okay, let's come to the question here. A loan agreement for 1 crore rupees. A loan agreement for 1 crore between Zenith Limited and Meridian Bank is presented to the bank. The agreement appears to be signed by 2 directors as required by the company's articles. See, according to the company's articles, here directors have signed the document. Now, one of the signature was forged by the other director. The thing is, here one signature is forged by the other directors here you can clearly see that it is a crime. Okay, the bank having no reason to be suspicious granted the loan. Zenith Limited later discovers the forgery and refuses to repay the loan. So now you have to advise the Meridian Bank whether doctrine of indoor management applies or exception of the doctrine of indoor management applies to this question. Okay, let's analyze the question. See, so as per the question, doctrine of indoor management protects the outsiders from internal irregularities but does not extend to the cases of forgery. Here you can get the support of the doctrine of indoor management only for the internal irregularities and not for the forgery cases. Forgery is clearly case of crime. So now forgery renders document completely void. So this is what the problem, and there is no legal effect for that transactions. Whenever a contract made by the parties or else that contract has any criminal element, then it will be the void contract or else illegal agreement. When there is a illegal agreement, it is completely void or else void from the beginning itself. So here in this case, the contract made by the company is a void contract. There is no enforceability by the company because it is a crime committed by one of the directors because he made a forgery in the document, so that act is void ab initio. So now there is no enforceability for that contract. Okay, here company never assented to the contract. See, if a director did not give his consent, then that means there is no free consent for that contract. One of the directors forged the signature of the other directors. Here contract made without the free consent of the other directors. So in that case you can consider it as a contract is a void contract. Now, the fact that Meridian Bank acted in a good faith is unfortunately irrelevant. In this case of forgery, as forged signature cannot confer any authority. So because of the forgery, there is no authority to the Meridian Bank to enforce this contract. So now it cannot bind the Zenith company for the execution of this contract. Okay, let's see the legal provision. See, according to the legal principles, an outsider is not required to inquire into the regularities of the internal proceedings of the company. So that is a provision given in the doctrine of indoor management. This doctrine has also exceptions, one of the most critical being forgery. So here forgery is an exception to the doctrine of indoor management. So when there is a forgery, then you cannot claim the doctrine of indoor management as a grounds in a court of law to claim the compensation. Here it will be considered as a negligence by the company, so that it cannot bind the Zenith company for the enforcement of the contract. So the transaction made by the director is null and void, so that it cannot bind the company. So that is the legal provision. Now the conclusion. See, the conclusion is, since the transaction is founded upon forgery, it is null and void, so that Zenith company is not liable to repay the loan. So bank only recourse would be to sue the director who committed the forgery for fraud. Now here bank can file a case against to claim the compensation only against the director and not against the Zenith company. Here Zenith company is not liable for the liability because of the lack of free consent in the contract. So that is the problem. So that here you can give the conclusion like this. Here transaction founded upon forgery. So when there is a forgery in your contract, that will be treated as null and void. So void contracts don't have enforceability in a court of law. So that is the conclusion to be given in this question. Okay. Let's move to next question. Okay, let's analyze the question. So here the concept is from lifting the corporate veil, under that fraud or improper conduct. Okay. See the question. Mr. Raj was bound by the non-compete agreement. See, Mr. Raj was bound by non-compete agreement with his former employer, Tech Giant Incorporation, which prevented him from starting similar business for 2 years. Now, there is a negative term in this contract that restricts the Raj from starting the business which is competing with the tech giant company. Okay. Next, the Raj incorporated a new company, that is Innovate Solutions Private Limited, with his wife and brother as the only shareholders and directors. Now, Raj formed the company to carry the same business, but the thing is his wife and brother are the shareholders and director of that company. Okay. While he controlled all its operations from behind the scenes. Okay. The question is, Innovate Solutions started competing directly with the tech giant incorporation. Can a tech giant incorporation take a legal action? The question is, the Raj has started a company by using his wife and wife brother and formed a company, and he started competing with the tech giant company, where it made a contract with the Raj not to carry the same business. So now you have to analyze the situation, whether separate legal entity is applicable in this case or else exception is applicable in this case. Okay, let's analyze the question. See, Mr. Raj has used the corporate structure of Innovate Solutions to breach his non-compete agreement. The sole purpose of forming the company is just to breach the obligation of his contract. The thing is, straight away he can't carry the business. For that purpose, he tried to misuse the legal provisions given in the company law. That is the formation of company. So as we discussed in other part, a company is a legal personality or a juristic personality. It will get the contractual capacity. It can carry any transaction or else it can carry any business or else occupation. So now here, to avoid the legal obligation, instead of starting business himself, he started a company and carried all those activities which is restricted in his earlier contract, that was carried by the company with the guidelines of the Mr. Raj. Now clearly you can find that this one is a fraudulent activity or else improper conduct by the party. Okay. Next one. See, that you have to write here. So the point is, company was formed with the sole intention of circumventing the legal obligation owed by its promoters. Now you have to see whether separate legal entity is applicable or else exception is applicable here. Now let's see. According to the facts given in the question, we can clearly see that it is the improper use of the corporate form. Just to violate the legal obligation here, Raj has formed the company. So let's see the legal provision related to this question. Separate corporate personality is the feature of company, but court will lift this corporate veil to prevent the corporate form from being used from fraudulent, illegal or else improper purpose. So according to the facts given in the question, you can clearly understand that the act done by the Mr. Raj is a fraudulent activities or else improper conduct, that is to avoid the legal obligations which is in their legal contract. So now here court can lift the veil to prevent the evasion of contractual obligations. So that is the conclusion to be given in your answer. Here Raj has made a wrong, that to commit the or else to violate the legal obligation, he has formed the company and he misused the company's legal status. Let's see the conclusion part. See, this is the conclusion. Here tech giant incorporation can obtain the injunction against both Raj and his company to stop the competing business. So according to the agreement entered into between Raj and tech giant company, here tech giant company can obtain the injunction from the court. So the separate legal entity status will not protect the Mr. Raj in his situation because he committed the fraud. So here tech giant company can claim the injunction order from the court by applying the case against Raj and his company. So that will be the conclusion for this question. So this is all about important topics in the first unit, and also I attached the PDF copy in a description where you can find the revision sheet along with the question answer that you can refer for your exam. So that will be helpful for your next exam. Okay students, if you find this video informative, and please do share this with your classmates or else those who are giving the CS executive exam, so that will be helpful for them also. And please do subscribe our channel for more such a contents. Thank you.